The Supreme Court appears poised to strike down President Donald Trump's attempt to end birthright citizenship. A majority of the 9 justices appeared skeptical of the government's position during 2 hours of arguments Thursday. The order would limit citizenship at birth to only those born to U.S. citizens and legal permanent residents. The court is expected to rule in the case by early summer. Joining us now is attorney and professor emeritus of political science at St. Peter's University, Alain Sanders. Professor Sanders, thank you so much for your time today.
My pleasure, Robert.
So it seems the court is prepared to strike down the president's attempt to end birthright citizenship. Why do you think that is? What did you hear during arguments?
Well, I think it's the case for 2 reasons, basically. First, the 14th Amendment is pretty clear in its language. It says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Now, we'll talk a little bit about jurisdiction in a minute, but it's pretty clear language. And then secondly, we have a precedent of over 125 years, which basically said if you're born in the United States, you are citizens of the United States. So you've got the clear language of the Constitution, and you've got a 125-year-old precedent. Now, what do I mean by jurisdiction? Jurisdiction is a very simple term in law. It means the power of a government to exercise authority over persons or things within its territory. Well, if you're born in the United States, you are under the jurisdiction of the United States. You're subject to the laws of the United States. And therefore, it's pretty clear from the plain language that you would be a U.S. citizen according to the language of the Constitution. Now, the administration has tried to stretch the meaning of jurisdiction by saying it really refers not to the power of a government over its territory, but really to the political allegiance of a person, and that political allegiance, that primary political allegiance, can be demonstrated by a person's permanent domicile. That's not what the Constitution says, and so that's why the Supreme Court, I think, has been quite skeptical.
Sure. Professor, let's look at the other side of this. What would happen if the court didn't strike it down? How would we begin to determine which babies are eligible to be citizens?
Well, that's the nightmarish scenario, because, of course, it would depend on what the court would say. We'd have to wait and see what the actual language were. But basically, if you're going to accept the administration's point of view that it determines, it's determined by the primary allegiance as exemplified by domicile, then you're going to have to start to question babies. You're going to have to question parents. You're going to have to look at where these folks have lived, whether it demonstrates permanent domicile. I mean, it's a nightmarish kind of scenario. That's one of the reasons, by the way, in the arguments that some of the justices said, well, how are we going to determine this? If we use your standard and what you're arguing, how in the world are we going to determine which newborn babies are actually citizens of the United States?
Right. Too much legal gray area and potentially setting up very tough challenges down the road. Professor Alain Sanders, thank you so much for your perspective today. We really appreciate it.
My pleasure. Take care, Robert.